Welcome back. What are we going to do? Told you last time, you only got one of two options. We can either conspire together to make this world a better place for ourselves and our children, or you can pick a number and get in line and wait for the government to take everything you have. Because they're already doing it. I got the warrant for Angela. The last video, I got the warrant. And what did I say? I said, they're not going to have a verified complaint. They're definitely not going to have a third-party impartial witness. But just for kicks and giggles, let's just go ahead and accept that they don't have a third-party impartial witness. And let's look at this. Okay. Complaint comes now. Who's coming? The state of Missouri. I don't know who the state of Missouri is, do you? I don't think they move anywhere. By and through the undersigned assistant prosecuting attorney on information and belief that there is probable cause to believe. They have information and belief that there's probable cause to believe. You mean, I think maybe something could have maybe happened allegedly? You don't have any facts with that. You got information and belief that probable cause belief. Believe. You just believe something happened. I don't believe you because you lie to me all the time. That the above named defendant committed the following crimes. Count 1. Tampering with a judicial officer. Class D felony. I don't know. I'm pretty sure that Nicole, who wasn't acting as a judicial officer, was tampering with Angela's right to be a parent, be a mom to her daughter. And I'm pretty sure she was tampering with her daughter's right to not be molested. Oh, and by the way, nobody knows where her daughter is right now. Not the state, not the court, not the GLAs, the GALs. Anybody who's supposed to protect her. Remember, because that one attorney said that's not how the real world works.
Those things aren't going to happen. That's not the real world.
That Angela, in violation of RSMO 575.095 and subject to punishment under RSMO 557.021. Did you understand any of that? And they call sovereign citizens crazy because they have this strange code nobody can understand. In the county of St. Louis, state of Missouri, committed the offense of tampering with a judicial officer, and that the purpose to harass, intimidate, or influence a judicial officer. Nicole Zellweger, that thing, that female, not even feminine, and that defendant sent a threatening email to Nicole Zellweger, the thing, in which she threatened the thing. They say judge. She is definitely not a judge. By stating there would be consequences for the judge's conduct, for that thing's conduct, if the judge did not change her ruling. 575. Blah, 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 blah. The undersigned prosecutor informs the court on information and belief that the above offenses herein charged were committed. Upon information and belief, you mean not on oath or affirmation? You mean not verified? Well, let's keep going. Okay, this is probably verified, right? I, Tanner Hale, DSN 0312, I don't know what that means, Clayton Police Department, knowing that false statements on this form are punishable by law, state the facts contained herein are true and documented in report number 21-261. I have probable cause to believe that on March 5, 2021, Angela committed one or more criminal offenses. You mean you don't even know how many criminal offenses you're charging her with? You don't know if you're charging her with one or more? And you're saying you want us to trust your facts? For real? And you're not even swearing to this under oath or affirmation. Just knowing that statements on this form are punishable by law, and you know that might mean something if we actually had any law, but we don't. And you're not putting this on your oath or affirmation, that's unlawful. There's no facts upon the record. What did I say in the last video? The facts supporting this belief, not a fact, are as follows. Judge Zellweger was the thing presiding over a custody dispute involving defendant's daughter. No, it was Angela's daughter, not defendant's. The thing had received multiple emails from Angela in the past. The email identifies the sender as Angela Freiner from Gmail. And you know what? You didn't actually see her send it. You don't have first-hand information of the facts. How do I know that you didn't just create that email to bring some trumped-up charges against her because she leaked a video of Thing telling a little girl to go stay with a child molester? On 3/5/2021, Thing received an email from the previously mentioned email address that stated in part, and the only reason I believe that she actually sent this email, because, you know, their word and their credibility is no good with me. But the only reason I believe this is because this is basically what Angela told me on the phone. And, well, I trust Angela. Okay, the court does not have the right to hold my daughter against her will or traffic her across the country. You know what? I would agree with that. If she is not returned to me, there will be consequences for your conduct. Well, isn't that what Thing said from the bench? You have stepped over the line for any time of immunity as a judge. I'm sure she meant any type of immunity as a judge. Which brings me to one of my favorite words. Immunity. Do you know what immunity means? It means exempt from duty or public service. Exempt from service or duty. Well, guess what? If you're exempt from public service and duty, then stop interacting with the public. I agree, you should have immunity. You should quit interacting with us. But if you keep on interacting with us, I think there's going to be some consequences. If you guys don't figure out what law is, there's two types of common law. One's handled in a courtroom like civilized people. And then there's the other one. Here's my favorite part. Police went to defendant's residence to contact her regarding the email. Police knocked on the door. However, defendant did not come to the door. Police believed the defendant was present in the residence. You know, it's a really good thing you didn't swear under oath and affirmation to this. You want to know why? Because right there, I know that you didn't have a warrant when you arrested her. She told me on the phone, you guys just popped up out of nowhere. Y'all were hiding in the yard. You're saying on your on your statement, not even sworn statement, to obtain a bogus warrant. You're saying the same set of facts, which means you didn't have this bogus warrant when y'all were there knowing that she was inside, or thinking she was inside. That's law. That's law. And this is how lawless they are. And you want to know why they can do this? Because, oh, it's a judge. He has power and authority. Hey, come give me your kids. I'm gonna write an order. I'm gonna sign it. I'm gonna order it. Come give me your kids. Oh, but you'll let them take them. You'll let them take them. But what's wrong? I'm not good enough? What, you don't find me, like, funny or something? Let's see what this warrant and commitment to jail for trial or preliminary hearing. Warrant number. You know, I think that's really funny because this isn't a warrant, because it's not supported by oath or affirmation and first-hand knowledge of the facts. Okay. Based upon the available information, not facts, upon the available information that comes from beliefs of somebody who's not even willing to testify to them about the individual circumstances of Angela and the case pursuant to MOSCT rules 22.04A and D and 33.01E, whatever that means, but I'm sure it's worth locking up Angela over. I'm sure that that's the correct thing to do and the non-terroristic thing to do. Are you kidding me? The court has considered the following factors. That's funny because the court can't think. I wonder how the court considers. The nature and circumstances of the offense charged. The weight of the evidence against the defendant. Well, how do you consider the weight of the evidence against against Angela when you don't even have any evidence? You don't even have any facts. You didn't even put the email in here. And this piece of paper isn't sworn to before any type of officer. It's just saying knowing false statements are punishable by law. Angela threatened Thing over custody trial. Let's see what they're going to do to Angela about that. The court further finds reasonable grounds, not good ground, to believe. They find reasonable ground to believe Angela is a danger to the crime victim, the community, or another person. Because she seems so awful and violent, because she wishes to protect her child from being molested. Yeah. Monetary. After consideration of the above factors, the court orders, I guess upon its own motion, because nobody's moving for anything, monetary consideration added based on the findings contained herein. Non-monetary conditions alone are not sufficient to secure the safety of the community, crime victims, or others. Because, again, Angela's so dangerous for wishing to protect her child. And you know what? I wish the Thing was a victim. I really do wish the Thing was a victim, because a victim is a sacrifice to a god. And somebody should sacrifice that thing. Section A, defendant is ordered to comply with the following least restrictive conditions of release. Compliance with the conditions of pretrial release program. No alcohol, that's kind of lame. EHD bracelet, I don't know what that is, with GPS, so they're going to track her every movement. Proof of installation payment prior to her release. So they're going to make her pay for her own enslavement from their bogus warrant that doesn't even have any facts to it. Defendant cannot be within 100 feet of the thing. No firearms and weapons. That's kind of lame. But she has a right to bear arms. Like, you're going to take away her right to protect herself from you? This is what the government wishes to do. Wake up. They're already doing it. They're already doing it. Okay? No drugs except as prescribed by a doctor. That's kind of lame. No contact or communication with victim and nothing. And again, I really wish there was a victim to this. I really do. I think the only victim is Angela, who's being further victimized because the public doesn't know what to do about this, because they don't understand there's no facts on the record. In addition to any conditions stated in Section A, defendant's bond is set at $75,000, cash only, 10% not authorized. So we are going to make you purchase us a nice Mercedes-Benz in order to have a little bit of freedom, where you still got to pay, on top of buying us a Mercedes-Benz, you got to pay for a GPS thing so we can track you and make sure you don't get out of line, because you're acting like a bad slave. Angela must comply with all municipal, state, and federal ordinances and statutes of the state, worship the statutes. Angela must personally appear at all court dates. If the defendant is charged with any of the following as concealed kid, Oh, and here is a fraudulent. See, this isn't a judge who signed this, because a judge can't sign a bogus warrant. But Dean P. Woodlamer, I don't know how to pronounce his name. Dean P. whatever his name is, he signed it. You gotta hold him liable? Or does he have immunity too? And if he has immunity, then why is he interacting with the public? Why is he interacting with the public? How more obvious does it have to be? How more obvious does it have to be? And what, you're not going to do something just because it isn't happening to you? That's how Nazi Germany started. That's how Nazi Germany started. Oh. There's the facts. I was right, 100%. There are no facts upon the record. Miss Zellweger, whatever, and Dean have acted outside of their judicial capacity, committing fraud upon you, the people, upon your sister, Angela, upon her daughter, who nobody knows where she is right now, because... Oh, they're exempt from doing anything to help her and protecting the public. That's right, because they have immunity. And we got no victim. Although I wish we kind of did have a victim. Yeah. So you got two options. You can join this conspiracy to restore Angela's freedom, to get back Sierra's children, and people are kind of contacting me with a list of things to make right at this point. Or you can pick a number and get in line and wait for this to happen to you. The choice is yours. But I wish to conspire if you do. Let's create a conspiracy fact with each other. Because those conspiracy theorists are crazy. And the sovereign citizens, they're the worst. The people who think they're sovereign and a citizen, like judges and, state officials. I heard a really good joke the other day. It was something like, if you steal an apple, you're a thief. And if you're still a kingdom, you're a statesman. That was pretty good. That was pretty good. So I'm just going to put this out there, and if the government takes away everybody's rights, I'm going to say I told you so. You only have two options: having fun or freaking out. And that's what it's all about. One world, love, and peace. I got your warrant.
You got my warrant?
Yeah, did you get a copy of it yet? Yeah, I got a copy of it. It's bogus. They don't verify any facts on it. Did you ever talk to the judge?
No, not until 9.
Yeah, okay. All right.
Yeah, I'll play stupid with me.
Hey, here, I'm going to read the warrant to you real quick. I did a video on it, and it's rendering down right now. I'm going to publish it tomorrow afternoon. But here's the thing. So, your statement, like what should be the declaration where somebody's actually testifying, it's Tanner Hell, DSN 0312. And what they're saying is, knowing that false statements on this form are punishable by law, state the facts contained herein are true and documented in report, I have probable cause to believe. They have probable cause to believe. They can't charge you with a belief.
Right.
Okay? They don't have any facts. It says right here, it says the facts supporting this belief. They don't have any facts. And nobody swears to this. Like, nobody swears to this under oath or affirmation. It's not affirmed. Okay, so it's a bogus warrant. And then down here at the bottom, it says police went to defendant's resident to contact her regarding the email. Police knocked on the door. However, defendant did not come to the door. Police believed the defendant was present in the residence. So they, like, because this is in the warrant, in the application for the warrant, they didn't have the warrant when they came to your house.
That's what I knew they didn't.
Okay, so those are the things to point out. Require the warrant. And
on false
yeah,
pretense?
no, they didn't have the warrant when they came there to arrest you. Okay,
That's why they didn't show me anything.
and that nobody verified the warrant. The warrant wasn't issued upon oath or affirmation. It's unlawful. It's fraudulent.
So what do I do?
You tell the judicial officer that there's no affidavit to it, and if they show you that piece of paper, you tell them that nobody swore under oath or affirmation. There's no facts that appear upon the record because nobody's swearing under oath or affirmation that they're true.
So
And all of the facts are based on beliefs. Okay? Like, let me read you this part of the criminal complaint. Okay, it says right here, it says, Assistant Prosecuting Attorney on information and belief that there is probable cause to believe, okay? They have information and belief that there is probable cause to believe you did something. They don't have any facts.
Or that I would do something, or that
No, they don't have any facts. They have information. They have a belief that probable cause is believable. They don't have any facts.
Okay.
Does that make sense?
Yeah, so I have to wait until I see the judge because they act like they don't have a judicial officer for me to speak to.
Yeah, and I mean they're just jerking you around, but yeah, the judicial officer who signed this is Dean P. Waldmer.
Well, I've never heard of him.
Yeah, I haven't either. But by putting his signature on a warrant that hasn't been supported by oath or affirmation, he He's not acting as a judicial officer, and he's committing fraud upon the people of Missouri.
Okay.
Okay? And they're not going to recognize that, because they're not going to throw him under the bus. I would just tell them that they don't have a warrant because they don't have any facts to support a warrant. They don't have any facts supported by oath or affirmation. They only have beliefs that nobody has sworn to.
So how do I get out of here? Wait till I talk to the judge tomorrow night?
And that's what you have to tell the judge. You have to tell the judge that you require to see the warrant. It's your understanding that the warrant is not supported by oath or affirmation. There are no facts that appear upon the record of the court, and you require to leave immediately and have your freedom restored. And you don't.
Why can't I do that now?
Huh?
Why can't I do that now?
Because they're not letting you move before the judicial officer. You could do it right now if they allowed you to move before the judicial officer. That's why I told you to start begging them. Well, not begging them. Start requiring them to move before a judicial officer, because you should be able to do that right now. But because you can't, I'm telling you right now, this is the key for when you do move before the judicial officer. They don't have any facts upon the record of the court. Their warrant is bogus. It's not supported by oath or affirmation, placing any facts there. And there's no accuser to it. Okay? And if they wanted to play, they can't charge you with a felony without a grand jury indictment.
Okay.
Sorry, am I being a little too loud?
No. I need to hear this because I'm sitting here having anxiety, and I'm sitting here thinking, like, what the fuck, dude? I'm being terrorized by a judge, and I don't even know where my kid is because of this judge, and I'm stuck in jail and can't find my kid.
Well, I mean, it's even more messed up because it's a completely bogus warrant. Like, I mean, it doesn't have any oath or affirmation. Like, it's not supported with any facts. It's not supported by oath or affirmation. There are no facts upon the record of the court, and they don't have a grand jury indictment. You should not be in jail.
I should not be in jail, you're correct.
But these are the things that you have to know. These are the things that you're going to have to present. And also, when you go in there, it's not just enough that you say these things. You have to write them down and put them on the record of the court, because that's what makes it legal.
Oh my God, I don't know how to oh my God, it's so much, and I don't got a pencil.
Just write down. No, you can require from the court paper, pen, and ink. But just write down that there are no facts upon the record of the court.
No facts upon the record.
Yeah, no facts upon the record. The warrant is not supported by oath or affirmation of any testimony, and there's no grand jury indictment.
Oh my God, I'm going to have to call you in the morning. So there's no indictment, there's no facts upon the court, like written upon the court, and there's no what?
And there's no, the warrant's not supported by oath or affirmation.
Oath or affirmation, meaning no one's swearing to it.
Yeah, no one's swearing to it. The only thing they do is they state that they know they could be held, under the penalty of law, but there is no law.
Remaining.
Huh?
I got 3 calls. I'm going to see if this guy let me go before the Judicial Officer. Is that right?
Yeah.
Alright, I'll call you right back.
Hey, if he won't, freaking, ask him if there's any way that you could get paper, pen, and ink, or pencil and paper to write a legal document. They should give you pencil and paper to write a legal document. Because you have a right to access the court 24 hours a day, 7 days a week, even in jail.
Okay.
Okay?
Alright, I'll call you right back.
Alright, bye.